This intense and emotional moment follows a man standing at a critical turning point in his life. What starts as a small issue, failing to complete a required program due to unpaid fees, quickly turns into something much bigger. As the situation unfolds, it becomes clear that this is not just about one mistake, but a pattern of poor choices and past behavior that continues to follow him. The atmosphere grows tense as his actions and history are brought into focus. It raises serious questions about responsibility, change, and whether he is truly willing to take control of his life. Despite being close to completing what was required, the setback forces everyone to reconsider how committed he really is. In the end, he is faced with a powerful choice that could shape his entire future. He must either accept strict conditions and prove he can change, or risk losing everything he has left. This moment is not just about consequences. It's about accountability, growth, and whether someone can break free from their past and choose a better path forward.
And are you Mr. Cole?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same James Arlington Cole who was placed on deferred adjudication in 2019 CR 9039 for the offense of aggravated assault with a deadly weapon on February 12, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation condition number 4.
Oh, and I'm sorry, could you announce for the record?
Rick Payne for the state of Texas. My apologies.
All right, you may proceed.
Violation of condition number 14G. On or about the 31st day of May 2025 in Bexar and or Harris County, Texas. The defendant, James Arlington Cole, did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in a violation of condition number 14G.
How do you plead to that? True or not true?
True. Your Honor, I had.
Just one moment.
Judge, we're gonna be doing true with an explanation.
All right. So with regards to the other violations,
State will waive the other 2 violations, Your Honor.
any objections?
No objections.
Did you understand by pleading true to violation of 14G, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 14G?
Yes, ma'am.
Court will find 14G true. Is there proposed agreement?
There is not, Your Honor. Both sides are going to go open to the court with our recommendations.
All right. State, what are you recommending?
To revoke the defendant's probation, adjudicated guilty, and sentence the defendant to 6 years TDC.
All right. And defense?
Judge,
We'll have witnesses or?
no witnesses, Your Honor, just argument.
All right. What are you requesting?
What are we requesting for Mr. Cole to be placed back on deferred adjudication? And we like to explain what was going on with the MTR.
All right. Let me hear explanations.
Let me explain. First of all, on the BIP program, his deferred was transferred to Harris County. That's where he's from. He completed a lot of the BIP program over there. He was exited from the program because he didn't make his payment for the BIP program. Our best estimate is that he completed maybe almost 90%. He was talking about graduation.
So here's my question.
Mhm.
Do we have proof that he was exited from the program for non-payment? Now you can lower your hand. So here's the thing. Let me explain something to you. You're saying I was exited from the program because I was unable to pay. Okay. Your client, your attorney saying he was exited from the program because my client told me he was unable to play. It's like, where's the proof?
Can I speak, Your Honor?
Well, let me just be clear. So is this for failure to pay? That's what
That is our understanding, Judge. I don't know if probation has any more information beyond that, given the fact that this case.
Well, let's call probation in Harris County.
Okay.
And let's see if they'll zoom in. And if this is about payment, then we'll see what's going on.
We can find out.
All right.
That'll be fine.
Program itself.
All right. State, have you reviewed that?
I have not reviewed that, but I'll take her
All right.
word
So
for
if
it.
y'all want to review that, what I can tell parties is this. If the only allegation the state is going on is 14G, and it appears from what Ms. Abrams has said, the progress reports she received, there were 12 classes for BIP. He completed 11. And then they say that there's a balance that's due.
Yes.
And I'm assuming the balance that's due is not a balance of another class, but of funds. And what I can tell parties is I don't see how it will be appropriate to revoke him if he's done 11 BIP classes. He only has one more to do,
Mhm.
and he owes a balance.
And the court wants additional arguments, I'll go into it, but I'll wait for the court.
May the state step back for a moment, Your Honor?
Yes,
Thank you, Judge.
sure.
He picks up a misdemeanor assault, bodily injury Mary Coe had, which unfortunately we could not go forward because that victim was uncooperative, but it was a different victim.
All right, so I will listen to what you have to say, but let me explain something to everybody.
Yes.
Y'all are only going on 14G. And that's the only thing that I have before the court. Now, I see the motion to revoke, and I see there is a violation of number 1. There's a violation of 14U, but the only thing I've been presented with is a violation of 14G.
Yes, Your Honor.
And he's on deferred adjudication. And 14G, and if there's a disagreement on the facts that I've been given, let me know. The facts that have been given to me about 14G is he didn't complete his battering intervention and prevention program. There were 12 classes. He did 11. They kicked him out of the program because he didn't have money, and they're waiting for the balance. And then I guess he can take the final 12. That's what I'm dealing with. If people want to go on other violations, I'm willing to hear that. But you all have just gone on 14G. And what I have on 14G, I don't, well, it would not be appropriate to revoke someone who's done 11 of the classes. They only have one remaining. And the reason why they didn't do that one is because they didn't have money to pay for it. Now, if somebody wants to present some information to me that he could have paid for it, he just chose not to. He won the lottery. He chose not to use it for that. He chose to do something else. I'll hear that. But I'm just here for 14G.
And Judge, he did not win the lottery. In addition, Judge, he was doing really well the past year and a half. This is his first MTR. He's on deferred. He's employed. He has a CDL. He's a truck driver. He hasn't tested positive for any substances. He's tested all the time and come up negative. If you test him today, Judge, just in case there was any doubt, he would come out negative. He's been in jail in custody for about 30 days already. And we believe that if and he is motivated to get back on deferred. If you place him back on deferred, Judge, he's going to do anything the court wants him to do. If you want him to do the BIP course all over again, he's more than willing to do it.
Well, I don't think it would be appropriate to redo the entire course when he only has one class remaining. Is there something else, State?
I make one more additional argument, Your Honor.
Yes.
The violation of the BIP that Your Honor is aware of occurred over a year ago, and as Mr. De Leon said, his client is gainfully employed as a trucker, which I would assume pays well, and he's had a year in which to try and take care of that particular non-payment to the BIP issue and has failed to do so up to this point in time. Additionally, Your Honor, if Your Honor does not feel like revocation is appropriate, state would, and if Your Honor is considering continuing on probation, state would ask that Your Honor add a jail sanction to his probation that begins today.
All right. This is what I can tell everybody. There's one outstanding class. Am I correct in that?
Correct, Judge.
It appears so, yes, Your Honor.
And this motion to enter adjudication of guilt and revoke community supervision was filed on June 12th, 2025. And we'll have to look in to see when he was actually arrested on this, because sometimes motions to enter adjudication of guilt, they're signed, they're filed, and then if he was in Harris County, and if he were arrested in Harris County, he would have needed to be brought back to Bexar County. So these are your choices. You know you're proceeding on 14G. I don't understand about this thing from North Carolina on June 8th, 2025. But these are your choices. I can continue you. Or I'll sentence you to 2 years in the prison. Those are your choices.
Which one do you want? You want to be continued? You want to?
Well, I can tell you right now, based upon what's in the motion to revoke, maybe truck driving is not for you, because the violation, and I'm not considering it, the state didn't present any information, but I see it where it's alleged to have been committed in North Carolina. And I think that's related to he's driving his truck in North Carolina. So maybe he should not be allowed to drive in other states.
Absolutely. And I've had a discussion with my client, Your Honor, and if placed back on deferred, he knows that, if he gets in trouble again, he's going to be back in front of the 187. So he understands there can be, bad consequences. So, but he has reiterated to me, he does want to be placed on deferred, back on deferred, and he'll do whatever the court asks him to do.
Well, if he wants to be continued and deferred and continue to drive a truck, I'm not going to allow him in the state of North Carolina.
Fine.
I think he'll agree to that easily.
Is there anything else?
If Your Honor would, as you just mentioned, you can see it when you provide evidence of the number one, but just consider the fact that even after doing 11 of the 12 BIP courses, he picked up that number one. That's all I'm going to say.
Well, I don't know if that rises to the level of preponderance of the evidence, which is the standard of proof in motions to revoke. I don't know if that's something that rises to the level of proof beyond a reasonable doubt. If it's for a jury trial, I just see that there's something in North Carolina.
I present this to Your Honor if Your Honor would be willing to look at it over Mr. DeLeon's objection.
Judge, I'm going to object to that because they waived the number one allegation. So that's something for the court not to consider.
All right, that'll be sustained. So I'm going to deny the motion, alternate amendment conditions. There's to be no contact with the state of North Carolina unless he's ordered to be there.
Okay.
Legally ordered to be there, not by your employer says you need to drop off a load in North Carolina. You're not allowed in the state of North Carolina unless in the state of North Carolina, they have a hearing for you in a court of law.
Yes, ma'am. Understood.
Is there any other conditions you request, state?
For the defendant as well, part of the terms of this probation to have no contact with Tamisha Singleton. And that's, if I can spell it for the record, Your Honor.
You said Tamisha?
Yes, Tamesha, and then Singleton, Singleton.
Good. No objection to that, Judge.
All right. All right. So there's to be no contact with Tamisha Singleton, no residing with minors, no unsupervised contact with minors.
As this intense situation comes to a close, it leaves behind a powerful message about choices and consequences. This isn't just the end of a moment, it's the beginning of a new chapter that will test his commitment to change. The pressure is real, and the expectations are clear. Every decision from here on will matter, and there is very little room left for mistakes. He now stands at a crossroads where one path leads